It's been amended 10 times by Congress. And since it was originally enacted, Congress delegated and told the Department of Education, you shall adopt regulations that amplify the statute, which the Department of Education has done, and they, on a regular basis, update those regulations. I expect some additional regulations to come out in the not too distant future, because one of the great questions that's troubling school districts right now is, how does FERPA really comply with and interact with surveillance video that we have all over the place? And there's a divergence of opinion as to how it should apply and shouldn't apply, and it's one of the things that's being talked about and debated. But, so there are periodic revisions. Another development that happened along the way is many years after FERPA was passed, there was a movement in the state of Utah to say, well, we want to provide a little more protection in certain areas than FERPA provides. So the state legislature enacted a statute, and the statute does basically three things. It says, 1, you shall follow FERPA. 2, you shall train your employees on FERPA. And 3, employees aren't allowed to ask certain kinds of questions of students and not allowed to provide certain types of services to students without parental permission. And that's what we call Utah's FERPA, or Little FERPA. So even if someone were inclined to say, we don't want the federal government intruding on us, and a school district has that right. FERPA is basically a statute that says, if you take any federal money, you will abide by FERPA. And that, if you don't abide by FERPA, the federal government has the right to take away your special education money. They have a right to take away your Title I money, your Title III money, all the money you get from the federal government. But even if someone were inclined to say, we want to fight FERPA, we don't think it's proper exercise of federal authority, that's kind of a moot issue in Utah, because the state legislature that does control education, and there's no question under our state constitution and our state statutes, the ultimate authority for the maintenance and direction and control of education in Utah is the state legislature. The state legislature has so far told us, you shall follow FERPA. So given that fact, the policy that you had before didn't conflict with FERPA, therefore it was an appropriate policy. This new proposal is also an appropriate policy. It makes it simple. It just says we're going to follow state and federal law, and if we're going to follow state and federal law, that means we're going to look at Utah's Little FERPA statute, and we're going to look at the FERPA regulations, and we're going to look at the FERPA statute, and that's how we follow and comply. So either of those, from a legal standpoint, would comply with the statute. The one you've adopted, this new proposal. There is another thing I want to talk about, the most recent amendments, because apparently that's what causes people a fair amount of heartburn. And I want you to understand that those most recent amendments were not a result of, did not come about by, were not in consideration with anything that has to do with the Common Core. And I'm not here to talk about the Common Core today. I'm here to talk about FERPA. But so you understand, FERPA, the concept of assessment and accountability has been a big deal in education for what? 12 years now. No Child Left Behind. The first provision of the statement of purpose of No Child Left Behind was, we want to make sure there's appropriate assessment, and we want to make sure there's appropriate accountability. We want to make sure that educators, when they say this is the best way to do it, there's some data behind that. Well, as we've gone through this data-driven kind of exercise, we found that there are holes. One of the big holes is we say that we do this in early childhood education. Does it translate to what happens in elementary ed? And we say, you know, we have this great high school. It prepares our kids for college. But how do we know whether it prepares our kids for college? And to deal with some ambiguities in the statute, in 2011 they did amend FERPA to make clear that you may participate in a study that says, here's personally identifiable information. And if it were my children, it wouldn't say, you know, here is Ben Robson's information. What it would say is, here's our student number, whatever, and as you know, no districts use social security numbers anymore as student identifiers. You have a separate student identifier. But when you put that student identifier with the test score, that becomes personally identifiable and subject to FERPA. And what the new provision is designed, the new revisions is designed to do is to say, we can take this student number and tie it to a student number at a college and university and see if really there is some correlation between how we do things at this particular school translates to preparation for college. And so there was a provision that allows that kind of sharing of information. That sharing has to be done specifically by contract. That contract has to have specific provisions in it as to protect the data, so that while the institution that's doing the testing may have personally identifiable data, what's published is only aggregate data, just like happens with your testing right now, that when people do UPass or people do whatever, it's tested and then aggregated and sent back to you. So, these provisions were done for that purpose. That had nothing to do with curriculum in any state, whether it's Common Core or any other curriculum. It just had to do with how do we make sure that we're assessing things correctly, how do we make sure there's accountability, which is what we've been trying to do for decades in public education. I don't know if that answers your questions. If you have further questions, I'd be happy to address them.
I do have some questions.
Okay.
If that's okay. I've just been reading I printed out the state law, our obligation as a board, the powers and duties, they're just general duties of us. And the word is used that we shall many of the times, and then the word is used that we may. Can you just define the difference of shall and may and how that, it's totally catching you off guard, sorry.
No, you're not catching me off guard at all. It's one of the big things that attorneys look for. Is it mandatory language or is it permissive language?
Okay.
Shall means you must. May means exactly that. You may if you want to. In other words, school districts, there are certain things that the state says you shall do, and there are other things that the state says you may do. And FERPA is the same way. It says that, for example, most of the exceptions to FERPA, where you don't have to go get parental permission to release information, are permissive. If we have an emergency and we want to call the police in to help us with an emergency, FERPA tells us that we may release student information, personally identifiable information, to the police as necessary to deal with the emergency. We don't have to. We could say, we think the protecting that data is more important than the safety of the students. And I hate to be, a little extreme on that, but you have that choice. You get to balance safety versus, information. And so it is permissive in that regard.
So I'm just looking at this, I'll share it with you guys so you know. There are many things, I highlighted all in yellow what we shall do, and then there's some what we may do, and then there are even a few that we may not do. So that's, don't do those, I guess. But one of the things says that we're obligated to implement federal programs for Chapter 1. So we're obligated to provide this kind of things. We're obligated, it talks about curriculum, that we have to administer tests for the State Board of Education's measurement of progress. We're obligated that we shall use progress-based assessments as part of the plan to identify schools, teachers, and students, and how we're remediating and what we're doing in learning. We must develop signs for warning how we can stop failing students and help them make progress. Work with the State Office of Education where their practices consistent of our federal regulations and laws. And there are so many ways that we are required in what we're doing, and I think we do a good job on that. I had an instance, my daughter in high school had a medical issue in high school at a sporting event. They didn't have to call me, but before the ambulance call, or at the same time they called, and I met there at the same time the ambulance, and I appreciated that, and we do that. I think it's explained, but that was my first comment, that we have an obligation under state law, 53A3-402, that we shall do many of those things. We don't have the option of doing that. The other one, 301, how it applies that we shall enact policies and policies governing the protection of family and student privacy as required in this certain section. It says we may adopt policies related to the public student's confidentiality, and we may not. We don't have to do that. I mean, we're not required by law to do that. But the State Board of Education shall develop the materials for training our aides, and that's what we use in the training to help people understand the laws of FERPA. And I guess I'm a little concerned and feel badly about the couple of comments that were made about not returning emails. It was my understanding as a board member, and usually try to return emails, especially the first or second time, but after many times of the same things, I want you to know I read all of them, but not oftentimes don't respond to everyone. All the ones that came in over this Common Core, Jill forwarded all of us. Some of them just went to Superintendent and Vicki. They were all forwarded to the board members. So I have the whole list, printed all of them out in a file. I've read all of them. It was a little concerning to me also, Mrs. Gatmeyer, that more than a dozen, I was trying to count, people did one line, say no to FERPA. That to me, that's not an option. FERPA was in place so that we have a protection for our students, and it's important for me that we obey the law. We want that as part of our, at least I do, I want that as part of that. So I'm thinking that, I'm not sure that they understand what that means, and I think we need to make a reply and do a good conscious effort to let people do damage control. I don't know. Vicki, maybe that'll be your last job as you're going out next month, the damage control law. I don't know. I received, I will say, probably a third of the emails that I received saying thank you for having FERPA in our life from many of the teachers and a few citizens as well. You're welcome to ask about those as well. And then a lot of comments from many of you and family members. And so I appreciate all the concern, and way more than we've had. But it was my understanding when we had a comment period that we were taking comments for that period, and that's what I thought were happening. We took the comments the whole month, and then we're here to make a verbal decision and let you know what we have from those comments. So that's why they were not all answered, the emails of every one we got. They came in from several people, sometimes every day, several times. So we're not counting all of those emails, but from a person is what we made the list of. So that was lengthy. I don't think I have any more questions.
Any other questions I might answer for you about?
What would your recommendation, either
You know, I think either policy will serve you. You know, it is true that most of the things we deal with in FERPA, and to understand this, prior to 1974, a school district could do whatever. And actually, one of the big reasons FERPA was enacted is there was no mechanism to correct a record. If the school had it wrong, there was no guaranteed mechanism to allow a parent to challenge the record and correct it. So if you read FERPA, a big portion and a large part of its purpose was not just the protection of records, but it was parents, you have the right to inspect it, and after you have the right to inspect it, you have the right to challenge it, and you have the right to correct it. Important parts of FERPA. I think they're things that we're so used to because FERPA's been around for so long that if we didn't have those rights, we'd be extremely upset. And so it's important to remember that, you know, the regulations change on a regular basis. I think something simple like this makes it easy for you to not have to revisit it every time the regulation changes or every time. There's the Family Privacy Compliance Office of the Department of Education that provides administrative letters at times. They don't have the same force of regulation, but it's guidance. If you have this question, here's our official take. You know, there may be things that you want to consider administratively that you don't want to bring back for a policy discussion every time.